Hello, and welcome to the Law School Playbook. Today's topic is including counter-arguments on essay exams. So, beginning students particularly are looking for the quote-unquote right answer on a law school exam. But instead of thinking in such absolutes, I want you to consider that there's often more than one path to argue. There are two sides to a story, and each party to a lawsuit will argue different points to make their case. And so that's what including counter arguments on law school essay answers is all about. As we know, analysis or application is where the points are on a law school essay exam. So if you find that an element is met, consider what the argument would be that it is not met. So let's use an example. Let's say you find the act element met of battery, right? Consider what the attorney for the other side would argue to establish that it wasn't met or to undermine the fact that the other side is arguing it was met. So what facts can you use that might be an argument to support a different conclusion? Don't get too creative with this. So many students try to make a counter argument based on, what is not there or drag in outside facts. The professor will give you everything you need to make a counter argument. So, you know the relevant rules and sub-rules, but you're really thinking about what would the other side argue, and there will be facts in the fact pattern that support both sides that you can use to argue and counter-argue for each side. And then you may want to use the word however when you're highlighting, your counter-argument. Case analogies can also help to bolster counter-argument and argument, frankly, but whether or not you need to pull from cases depends on the course and the professor. So that's pretty professor dependent. Some like when you use cases, some like when you use case names. The majority of first-year courses require that you just know the law, understand how it works, and then using cases is sort of like, sprinkles on top of the frosting, on top of the cake. So don't focus too much on using case analogies to add support. So let's look at some examples. Here we have a simple issue in example 1 that draws from the fictitious swimming pool law course that we use in our outlining video. So it starts with Tessa is accused of violating the administrative pool rule that requires patrons to sign in upon entry. So here's an example of analysis with counterargument. And this is also, pay attention, following the IRAC paradigm, which is how we organize our answers to law school essay questions. So the first issue is whether Tessa violated the administrative sign-in rule when she bypassed the desk and went straight to the locker room. So we know, based on our video relating to issue statements, that that's a decent issue statement because it has part of the rule in there and it has some relevant facts in there. The pool rules require patrons to sign in at the desk upon arrival. So that's our R for purposes of our IRAC. Now we shift into the A. Here, Tessa proceeded to the locker room after showing her pass, thus she did not sign in. Now we look at the counter argument, which is in purple. Although Tessa may attempt to argue that showing her pool pass is sufficient, this argument will be unsuccessful because there is no pass exception to the sign-in rule. Consequently, and here's our C for conclusion, Tessa violated the administrative sign-in rule. It's as easy as that. You make your principal argument, you use the facts that are given to you to create a counter argument, say whether or not it's going to be successful. Usually you're dismissing it, right? Because otherwise it would be your primary argument. So you're going to explain it and quickly dismiss it, say why it's without merit, and then briefly conclude. Here's another example. A DoorDash delivery driver becomes friends with a client who ordered weekly throughout the pandemic. The client is a wealthy woman known for her philanthropy who mentions support of education. The client encourages the driver to attend truck driving school, saying that the tuition would be easy for her to cover. The cost is $6,500. The driver quits the DoorDash job and enrolls in truck driving school. The client makes an initial payment of $500, but then doesn't pay anything else. The client promises to pay full tuition when the driver graduates. After graduation, client refuses to pay. Driver and client never signed a contract. If driver sues client, what is the result? So let's think about this. We have the little warning symbol in here because we're not using it for the substance. We're using it for the skills lesson. But hopefully this comes to mind. Promissory estoppel. Okay, so let's assume for purposes of this example that we've worked through the first two elements of promissory estoppel. Now we're going to look at the third element or requirement for promissory estoppel, which is reasonable reliance. So this is going to be our mini IRAC in our essay exam answer. The third paragraph relating to the reasonable reliance element. So again, this is a mini IRAC, so it's going to start with a mini issue statement that hopefully includes words from the subrule and words from and facts from the fact pattern. Here, the driver's reliance was reasonable because the client who offered to pay for school was a wealthy woman known, for her philanthropy, who supported education. Further, her reliance was reasonable because the client encouraged driver to go to trucking school and they had become friends. Here's our counterargument. The client would argue it was no longer reasonable for the driver to rely on the promise to pay for the school when the client made just one tuition payment and then paid nothing else, right? So that fact can be argued for both sides. But now you're going to explain why that counterargument is without merit. However, the client again promised to pay the full tuition when the driver graduated, making the reliance reasonable. So there's our counterargument, and now we're going to briefly conclude. Therefore, right, and then we're going to provide our conclusion. Let's look at another example. D's brother lifted D's arm and used it to strike P. We know that this is probably a battery question, and we're going to examine the first element of battery, which we know is an act. And the subrule or definition for an act is a willful, volitional, or voluntary movement. So let's look at the mini analysis for that element of act with a counterargument. Here, defendant didn't act when he hit P, making a willful volitional movement because defendant's brother lifted his arm to hit P. Here's the counterargument. P may argue that D did act because his arm is the one that hit P. However, the act was involuntary movement caused by someone other than D. So you're introducing the counterargument briefly and dismissing it. Therefore, and there's our conclusion. As we know, the analysis is where the points are. Don't leave points on the table. The counterarguments are the icing on that beautiful cake, but keep in mind the call of the question. The call of the question may tell you to discuss counterarguments or may say present the arguments for both sides. The call of the question really drives the content of your analysis or application. So I hope this is helpful in explaining how you might introduce and quickly dismiss a counterargument. Think about both sides and arguments that can be made. That's really what we're talking about when we say you're thinking like a lawyer. The law is not black and white, and law school exams don't present a binary choice. There is a lot of gray in there for you to work with. So I hope this is helpful. As always, feel free to reach out with any questions. But in the meantime, just do your best and know that I'm rooting for you. Thanks.